Good afternoon, everyone. It is now 3 o'clock. I want to thank everyone that has joined so far for coming today on a Thursday at 3 o'clock to join us for our structural maintenance and 40/50 year certifications webinar. On behalf of Vesta Property Services, Florida General Counsel, and Eastern Engineering Group, we are very excited that you all took time out of your day to join us to learn more about your condominium and associations and making sure that we're all structurally safe and making sure that we're all following Florida statutes at all times. Just a couple housekeeping items to make sure that this webinar runs without disruptions. All participants will be muted and will not have the ability to join with video since this is a Zoom webinar. At the end of this presentation, within 24 to 48 hours, Vesta Property Services will be sending out a copy of the presentation along with the recording for any board members that want to see this later, or for any residents, or for anyone that wants to see this on their own time. At the end of this webinar, our presenters will go ahead and take questions from the actual participants today within the Q&A feature of Zoom. So if you see on the bottom or on the top of your Zoom webinar, you will see a little Q&A button. And if you have any questions, please do not hesitate to ask. We will try to answer all of them within time. So I want to thank you all for being here again today. We're going to go ahead and get started with our first introduction being Barbara Alvarez-Sanabria from Vesta Property Services.
Hi, everybody. Thank you so much for joining us for this webinar. I've joined Vesta in 2013, and I have been the general manager of the Southeast region since 2015. And then next is Hugo Garcia.
Good afternoon, everybody. I'm Hugo Garcia. I'm an attorney licensed in Florida and in the District of Columbia. Florida General Counsel PA was started in 2019. My areas of practice is community association, construction, and real estate. Currently, we have approximately 3 lawyers, 2 paralegals, and an assistant. And again, thank you for making some time today to attend this important webinar.
Hi, good afternoon, everybody. This is Raissa Lopez. I'm a professional engineer licensed in the state of Florida and in several other states in the country. I'm the president of Eastern Engineering Group. Eastern Engineering was founded in 2005, and we perform structural design for buildings and building components. We also do 40/50 year recertifications, inspections. We do threshold inspections and special inspections, and also we assist during the construction administrations of the project that we design. And thank you all for participating in this webinar.
So before getting to the fiduciary duties, you first want to know, how do you qualify to be a board member, and how do you get to that point to obtaining those duties owed to the association and to the homeowners in the association. So in Florida, we have what's called the Florida Condominium Act, which is under Chapter 718 of the Florida statutes. So there's 2 options to be to get on the board, let's go back, preconditions to becoming a board member is 1, first it'd be elected or appointed, and 2, within 90 days of being elected, each new board member has to certify in writing to certain criteria that they've met in accordance to the statute, which I put some of them here on the screen. And then the second option, or the alternative, is to take a course that's been approved by the division, the Florida Department of Business Regulation, by undertaking a course that's been approved by them, and usually is a law firm that does a course, usually free of charge, within 1 year prior to the election or 90 days after. So the purpose of the act is to give statutory recognition to associations and their condominium form. And in the second most important part is to establish procedures that create the condo association, and how are those operations to be conducted by the board members. So there's always some, not issues, but I guess you could say some misconception as to who qualifies to be board members when there's more than 2 homeowners. Usually only one of the 2 could qualify. You can't have 2 homeowners sitting as board members. Obviously with some exceptions. And of course, if you're a tenant, you don't qualify to be a board member. And I'm sure that Barbara could pitch in her experience where tenants will send emails to the property management saying that they want to be part of the ballot or be part of the election procedure. So I'm not sure if Barbara wants to comment on that. Can hear you.
We have seen it in the past where some tenants want to be part of the board of directors. And we've also seen it in documents, and Hugo could intercept on this one, where any member could be part of the board of directors. There is no, I've seen it in some docs, especially in HOAs, we'll see it where anybody could be on the board, including the tenant. But under Condominium Act, we also see that only the membership could be part of it.
All right, the next question, which goes hand in hand with this, is who does not qualify to be a board member? And it's typically those individuals who have been suspended or removed by the division, or who have been delinquent in paying their monthly obligations to the association. Those 2 criteria will disqualify you for being put or listed on the ballot, on the voting ballot. There's other criteria as well. That's pretty much states, and you can see in the second paragraph of this PowerPoint that shows that if you've been convicted of any felony in Florida or in a United States district, you're pretty much not eligible to be a candidate for the board of directors, as well as being convicted of any offense in another jurisdiction. For example, say you're in New Jersey and you commit a crime that in Florida is considered a felony. That's another grounds for not making you eligible or eligible to continue to be a board member of the association. Of course, there's always exceptions to the rules. If your civil rights have been restored, then obviously you could serve as a board member. And I'm not sure if Barbara, and her, based on her years of experience, has ever seen an issue or some kind of scenario where a board member has been suspended by the division.
Luckily, I have not intercepted that. The only time I've actually disqualified a candidate has been because they've been delinquent in their dues when they are moving forward towards an election.
We'll go to the next. All right. So with this, on this slide, regarding grounds for removal from the board, again, going back to the prior slide, it states, the statute state, we're not making this up, it's on statutes, that if they've been, delinquent for more than 90 days, is deemed to have been, pretty much the board member or the homeowner is deemed to have abandoned their office in the board, and therefore it creates a vacancy in that association, condo association. I'm not sure, well, Barbara just commented that she had to, suspend somebody, I believe you said?
No, we disqualified them. So right before an election.
Yeah. So, of course, additional grounds for removal from the board. Of course, if you embezzle or steal money from the association or property, you're going to be removed. That's an obvious one. Another one, another point to emphasize on is towards the last paragraph. So if you're charged with a felony offense, but it was, the judge or the jury found that you were not guilty, then you're reinstated back to that, to your term for the remainder of your term. So, the statutes do give you the option to go back, to be back and reinstated and continue serving in your position as board member, despite being initially charged with that felony offense. So remember, I want to emphasize this for felonies, it's not for a misdemeanor or small crime. I'm not sure if Barbara has seen this occur in her years of experience where somebody's been convicted of a felony and they've been reinstated after they were found to be not guilty.
I have been lucky not to have actually entertained that.
So the Florida statute, or we'll refer to as the act, it's kind of like the framework of how to run an association, condo association. It obviously has definitions, and the three that I put here on the screen, we'll go to the next slide. Right, so you'll see here that the act, there's obviously additional terms that they define, but the three main ones, in my opinion, are how the act defines association, how it defines board, and how it defines operation. If you look at where the act defines association and how it defines it, you'll see that it states that it's responsible for the operation of the common elements and for the operation and maintenance of other real property within association. And then going to where the definition of board is, or board administration, it gives a definition which states the board of directors, which is responsible for the administration of the association. So these keywords, administration, operation, and maintenance, those are keywords that that the act, you'll see it being repetitive throughout the act, really emphasizes on. And then the last one, operation, it defines it to include the administration again and management of the condo property. Going to the next slide. So you'll see, towards the end of every paragraph where I quote is where you can find these citations where in the act, if you want to go and confirm them for the wording. But the law is clear in the statutes. It's the operation of the condo shall be by the association, which must be a Florida corporation for profit or a Florida corporation for nonprofit. And I want to emphasize on the word shall. That word, I'm not sure if most of you know the importance of that word, but it means must be by association. So it cannot be by anybody else besides the association or its agents. So that's a very important keyword there. And then going down to the second paragraph, this bullet point here is great significance. Because it shows you that the operation of the condo association is governed by the articles of incorporation, if it's incorporated, and the condo association bylaws, which usually these two items are included in what's called the declaration, which is recorded in the county in which the association or the property is situated. And all this stuff typically is of public record. So if you ever want to be curious and see what a specific association's documents read, you can always look it up on the public records. So the next question you want to know or you want to ask is, what are the powers of the association? What can they do? What is their authority? So the statutes also list out, what are the powers of association, which you'll see here on the screen. Is the maintenance, management, and operation of the condo property. And those words are, as you see again, they're repeated throughout the act. So when you see words being repeated usually in statutes, it's because of their great importance. Going down to the I believe the second bullet point. An association can file a lawsuit. So you'll see here it says the condo association may institute, maintain, and/or appeal actions or hearings in its own name, meaning that it can sue under the association's name on behalf of all the unit owners of the association. And you'll see here where I want to emphasize is you see it's the first one where it says for the common elements. And you'll see here it says the roof and structural components of the building. So I just want to highlight that. Barbara, in your experience, what kind of lawsuits have you seen associations bring on behalf of their owners?
We've seen construction defect lawsuits, a bad roof, a vendor that didn't, any type of issues that they've had with the construction element. In recent, when we have like brand new condos that recently turned over from the developer, those type of lawsuits also come into hand where they are suing the developer for construction defects.
So, this provision here gives the association the power to sue on its own name. So we'll go on to the next slide. So usually I get asked a question as a lawyer, what are the common elements of my association? So, that terminology, common elements, it is defined in the statutes, in the act, and it's listed out here. I'm not going to go through each one. But I do want to emphasize though that if it's under the statute, all the way at the bottom, and this is directly from the statute itself, states that the condo declarations may also designate other parts of the condo association as common elements. So if it's not listed here, the declarations can also add on to this laundry list of items. The next question, becomes who's responsible for the maintenance of my building, of where I live, and it's the responsibility or the maintenance of the building of its common elements is by the condo association, and that's listed out in the statutes as well. They can also lease, maintain, repair, and replace the common elements as they deem fit. And I've put go to the next slide. I've put some examples of what courts have found to be common elements. Parking lots is one of them, where you see here the court found that the association had a duty to maintain the common elements in general and the parking deck in particular.
And to interject on that one, typically, most condos, some of them have deeded spots, and that's where I believe this lawsuit originated from, right? For instance, if they have a deeded spot in the parking area, that area could be maintained by the association because it could be considered a limited common element.
Correct. And two other examples, sanitary sewers and swimming pools. All right, so a hot topic right now in Miami, obviously after what happened, what occurred or transpired, is what are the fiduciary duties of a condo's board of directors? And again, there's a set of documents, a set of statutes that pretty much intertwine and put together what those duties are. And you'll see there in the second bullet point, it's the Florida Condo Act, which I've been going through so far, the declaration and the bylaws of the Condo Association, the Florida Business Corporation Act, and the Florida Non-for-Profit Corporation Act. These three acts, along with the governing documents for the association, they address the liability of the association's directors. So what is exactly the the directors of the association's fiduciary duties? It's that duty that's owed both to the association itself, but more specifically to the unit owners who live there. They have an obligation to those individuals who reside in that association, and the courts have, in order to come to that determination of what is a fiduciary, I'm going to go back of what is a fiduciary duty. You first have to establish what's called a fiduciary relationship, and as the court states there on the fourth bullet point, is a relationship that's based on trust, confidence between the parties, where confidence is reposed by one party and trust accepted by the other. A good example of this relationship is the attorney-client relationship, the accountant and its client relationship, where it's a relationship that's, that both sides are putting their trust into one another to ensue in a specific endeavor. And then the statute actually states in specificity what is that duty, and it's stated in the last bullet point there. It's they have to discharge their fiduciary duties or their duties in good faith, with the care and ordinary with the care an ordinary prudent person in a like position would exercise in those circumstances, and in a manner that she or he believes to be in the interest of the association. So while exercising this duty, they have to do what's best for the association itself. Going on to the next PowerPoint. This PowerPoint shows how that statute reads, which is section 617. You guys could go through it. But going to subsection 2 there, this is a very important subsection, and I'll tell you why in a second. Because while the directors, they undergo their fiduciary responsibility to the association and to its owners, they may rely on information, opinions, report statements, financial statements, if they're prepared or presented by, and it gives you a list of those items could be prepared by, and it states on subsection B, legal counsel, public accountants, and other persons as to matters that the directors reasonably believe are within the person's professional or expert competence. This also includes engineers and property managers as an example. So, any reports or items or opinions that, engineers or, experts or, general contractors rely upon or come to, put forth in a report that these, board of directors rely upon. However, like every rule, there's an exception on the last one there on number 4, subsection 4, it states a director is not liable for any action taken as a director or any failure to take any action if, and that's a key word right there, if he or she performed the duties of his or her office in compliance with this section. In other words, this is pretty much excluding what's called individual liability. As long as they comply with this section, they're pretty much immune from liability. But subsection 2 is a significant one, concerning what transpired recently, because as a director, you could rely on information of third parties if you believe that they're competent enough to put forth those reports. So we'll go on to the next PowerPoint slide. All right, so this section of the Act, of the Condo Act, which is section 718.303, is of great significance. You see there where it states action at law or inequity or both for failure to comply with these provisions may be brought by the association or by a unit owner. So this provision here is made to give what's called a private cause of action against a director for failure to comply with the Florida Condo Act. So this pretty much opens up the door to filing, a unit owner filing a lawsuit against either the association or its directors. Barbara, have you ever seen unit owners come together and bring a lawsuit against a director? Can't hear you.
No, I haven't seen that.
I have seen some cases, some case law where unit owners have come together and brought lawsuits directly at the individual directors, and I'll highlight that case. So going on to the next slide. So the Florida courts, and when it comes down to what's called director liability, have put together this rule, what's called the business judgment rule, when faced in determining whether a director has breached its fiduciary duty in maintaining, repairing, or replacing the association's property. As you see here, this rule suggests that the decision of the directors will not be questioned unless, and that's a big one right there, and that's, this language here comes directly from a case that's cited there, Sunny Boy versus Sanani. I'm not sure I'm pronouncing that correctly, but that word unless, it's one to emphasize on, unless there's a showing of fraud, self-dealing, dishonesty, or incompetency. Going on to the next slide. So reiterating the rule, the law in Florida is clear. Absent fraud, self-dealing, betrayal of trust, directors of the condo associations are not going to be personally liable in their individual capacity for decisions that they made while they were serving as the directors of their condo association. And I listed here some cases. There's about 5 or 6 cases there, which show is, the courts are very reluctant to find what's called individual liability. I mean, liability in their individual capacity. They don't want to open up the door for these directors for either the association or for unit owners to go after them personally. Of course, unless there's fraud, self-dealing, and things of that nature. Barbara, have you ever been in a situation where a board member has either committed or attempted to commit some type of fraud or self-dealing or something of that nature?
No, luckily we have not.
Yeah, it's not very common. So the ultimate question becomes why so much immunity for these these directors that are pretty much maintaining or operating the associations. Why so much immunity towards them or for them in their individual capacity? And one for the court actually wrote out exactly what the court wanted to emphasize as to that point. It's the case of, I cited there's Perlow versus Goldberg, where it shows that the court recognizes that it'll be difficult to find persons willing to serve on condo boards if immunity from individual liability in the instances of simple negligence was not upheld. So in other words, what I suspect what the court is trying to say here is that, listen, we're all human beings. We all, have committed some type of mistake. But if your mistake is to the degree of fraud or something of that, gravitude, we're not going to immune you from personal liability. You will, suffer the consequences. But the court they want to encourage people to volunteer their time to serve on their boards, because without them, there's pretty much no operation of the association. So from my end, that's from the legal standpoint and from the acts, and that's regarding the fiduciary duties. That's the main points, in my opinion, that pretty much close up that topic.
Okay, let's start with the structural part of the presentation. And in Miami-Dade County, since 1975, it became an order from the Florida statutes to have all the buildings that are more than 40 years old to have the 40-year recertification for structural, and that came after a building collapsed around 1974. So in 1975 was implemented that rule, and after the Hurricane Andrew came in 1994, then the electrical portion of the recertification was added to that statute. And the statute is for Miami-Dade County and for Broward also, and it stipulates that all buildings except single-family residence and duplexes shall be recertified when they become 40 years old or longer, 40, and then after the first 40 years, then the recertification shall be done at intervals of 10 years apart. Next. What's a 40-year recertification? That's basically an inspection. It's a visual inspection that's intended to ensure that the building is structural and electrically safe for the continued use, and that will depend on what kind of building is that one. If it's a residential building, then if it's a warehouse, what's the use of the building is very important, and that's also a way for the buildings departments to have a written report and a written certification and have on records that the building is safe for its continued use. So after the building turns at 40 years old, the city sent a notice to the owner of the building that the building is due for the 40-year recertification, and the owner has 90 days to submit that written report. If the owner fails to submit that report, then the building department send a notice of referral to the unsafe units. And the building official in this case, if no action is taken by the owner of the condominium association, the building official has the ability to revoke the certificate of occupancy of the building. If repairs are needed on the building, are found to be needed, then the owner has 150 days from the day of the notice to conduct those repairs. And all repairs need to comply with the requirements of the Florida Building Code. Next. So the purpose of the structural inspection in this case is to confirm in reasonable fashion that the building is safe for continued use under the present occupancy. And that inspection is a visual inspection. Usually we don't, sometimes the documents of the building, when I mean documents, I mean the plans, the construction plans of the buildings are not available. If they are available, that would be great for the engineer to review those plans before the inspection is done. And the reason for that is it's good to know what the structural system of the building that we will be inspecting consists of. And in the report, you need to specify what that structural system is. So if you have the plans, that's perfect. If we don't have the plans, then we have to go by visual examination of all the structural elements of the building that are exposed. Sometimes, if concealed spaces are, like I said, concealed and not. We're not able to view, for example, slabs or columns that are concealed. If we found that is necessary, we need to ask that the small openings are done so we can inspect the structure behind. Next. Yeah, sometimes there's obvious overloading, and that usually or sometimes happens at warehouses or mezzanines. And so in that case, if we see that that's a deterioration of columns or slabs due to overloading, sometimes we need to require to see, we need to check the design. But usually we don't check the original design of the building. This is just a visual inspection. Now, it's very important that the effects of time with respect to deterioration of the construction materials is evaluated. Sometimes, for example, buildings that are 40 years old or maybe older and are very close to the ocean in coastal lines, the concrete is like very deteriorated, and we can actually see that when we examine the building. So sometimes testing is necessary to be conducted, not always, but sometimes, and because we need to at the end of the day, we need to attest that the building is safe for it continue use. So it's very important that we check on the materials that the building have. Next. So like I said before, visual examination is conducted throughout all habitable and non-habitable areas of the building. And what we're looking for is like cracks, distortion, sagging, excessive deflections, misalignments, signs of foundations that are settled, not in in a different way. So you have like differential settlement, and you have concrete spalling, you have exposed rebars. Those are the things that we are going to be looking at when we inspect the building. Railings in the balconies are a very key and important elements to inspect. Usually, you know, balconies are exterior and are very exposed to the elements, and we live in a very in a weather that, you know, it's very sometimes hot, and then we have rain. So those exposed structural elements, such as balconies, are the ones that start deteriorating first. And railings are very important because they can become like a life-threatening element. So sometimes, and that even happen in newer buildings and not in buildings that are 40 years old, but when you have an aluminum railing that has, like, for example, that picture that we're seeing there, it's core drilled into the concrete. Sometimes that connection is not very well done since the very beginning that the building is built, and water start accumulating in that pocket. And with time, the railing can deteriorate. I mean, if it's steel, corrodes. If it's aluminum, also can have become like unstable, and like I said, it can become like a life-threatening situation for the railings. Next. Okay, testing usually, like I said, is it's not very often that we have to order testings, but sometimes we have to. I mean, when we see that the concrete is deteriorated, sandy, so we can order a concrete strength on the test for the concrete, or if there are concerns on differential settlements of the building, that the soil might be failing, and at some, maybe the building is very close to a lake, or you can see that there are obvious misalignments on the structure, we can order a soil study done by a geotechnical engineer, and sometimes foundation needs to be, I mean, you need to like stabilize the foundations with additional supports. Next. So chipping areas of concrete and surface finishes are encouraged when we see that there are problems. And sometimes, like I said, visual examination is insufficient, so you need to go step forward. Ceilings and other construction finishes might have to be open, so we can see the actual structure that's concealed. Such as, I mean, this very important to examine the key elements on a building. Usually buildings are built out of concrete, so columns and slabs are key elements on the structure. And special considerations shall be done. I mean, we have to pay special attention for exposed slabs and such as balconies, edge of slabs, which are more susceptible to the corrosion. Roof, when we examine the roof, we look for water ponding on the roof, for the what's the support conditions of the heavy equipments that are usually on the rooftop units. Those are key elements that we have to inspect when we do the 40-year recertification. Next. So basically, I mean, there's two basic considerations here, the movements of the structural components with respect to each other, Like I said, we live in an aggressive weather, and we have high temperatures, and buildings change in volume with time, and they're constantly changing. So we also have high wind events like hurricanes, and buildings move, and components moved. So it's very important to, especially for the people that lives in the building, it's very important that they pay attention to everything that happened in the building, because at the end of the day, I mean, the condominium association, there's some people that live in the building, but all the residents, it's important that they pay attention to the things that happen in the building. Maybe like you have a water leak, everything needs to be reported. So, proper repair methods are done in a timely manner. Sometimes also structural members have not sufficient cover. For example, I mean, in a concrete column, you have like vertical reinforcement, and you have the ties, and then you have a cover. And what happens is that when cracks start happening in a structural element, water start getting into that element. So, and the reinforcing starts, corroding. When the reinforcing starts corroding, then the concrete cracks, and then at some point, that piece of concrete from the reinforcement out is falls. So it's important not only to, when repairs are done, not only to repair what, the element that's damaged, but you need to go to the root of the problem. You need to determine what is causing that water was getting into that element. For example, I mean, we have several buildings with, this is an example, with planters in the common areas, and then the parking lot below. Or so you have water. If you don't have a water proved, below the planter, then water start getting into the structure, and then you start having leaks on the structural slab, and water seep through. And window sealants, that's also an important material to take very good care of, and those are components that have a life. I mean, have a warranty, sometimes 5-10 years. So the condominium association and owners need to pay special attention on those elements that are key. Having a good sealant on the window prevent water infiltration into the stucco, into the walls, into the slabs, and start with, with time, start damaging the structure. And repairs are not cheap. Repairs are very expensive. So if the repairs are not done properly, then money is wasted, because, if you don't go again to the root of the problem, then you're going to start having damaged elements really soon. Next. So on the report that we have to submit to the building department, we need to attest all the deficiencies found during the inspection. And we need to know all the problem areas, and we have to recommend what repairs do we recommend. Sometimes if we see that there are immediate action that shall be implemented in beams or slabs or any structural element and that requires shoring, that shall be reported immediately to the owner, so action is taken. And the shoring is designed by a professional engineer, licensed professional engineer that's specialized in shorings. Next. Okay, in the evaluation, in the report evaluation, we need to describe all what's the structural system of the building. Like I said at the beginning, if we have the plans and we know, I mean, the building has steel columns and beams, and then combination of metal deck and concrete, or if it's all concrete, or if it has a wood roof, all that structural system needs to be stated on the report, and the conditions of the system. conditions of the masonry walls, the stucco. We need to conditions of the windows. The buildings, of course, they don't have to comply with the current requirements of the Florida Building Code. For example, if you have railings and the current code called for the height of the railings to be 42 inches height above the floor level, there are several buildings that they don't comply with that because they were done in a very previous code. And if the railing is sound, is safe, is hard enough, that's perfectly fine. We're not looking for code compliance here. We're looking for structural conditions of an existing building. So it's very important to for example, for the windows, to maintain in good conditions, the gaskets, the sealants, because they prevent water infiltration into the structure. To maintain the building, the exterior of the building waterproof, it's very important to maintain the paint of the building in good standing. And sometimes paint manufacturers give like 5-7 years of warranty. Our recommendation is to repaint the building after the warranty is going off. Next. At the beginning of the report, we need to provide a statement that says that the building is structurally safe, unsafe, safe with qualifications, and or if repairs are needed on the building. So if repairs are needed, the engineer shall instruct the owner or the association about what kind of repair documents do they need. And repair documents are plans that are prepared by an engineer or an architect. And those plans needs to be approved by the building department. After the plans are approved, then they can go on to bid, or they can, condominium association or owner can receive estimate from different contractors, and then ultimately the contractor is the one who gets the permit at the city or the county to perform the repairs. So next, repairs in this case shall be very, I mean, the contractor selected by the owner and the engineer shall work very close by each other. And because like I said before, if the repairs are not done properly, then, you know, money can be wasted. And the engineer shall ensure that the repairs are done in a proper way so they can be permanent, or they can last for several years. And usually, for example, engineers can check what are the extension of the damage. Let's put, for example, like a building that has water infiltration and that has stucco problems on the exterior. Then you engineers, they get on a swing stage and they go knocking on the exterior stucco of the building, looking for the soundness of the stucco, and then, you know, what the extensions of the areas are. So those buildings are marked. And then after that, the demolition work starts. And it's very important, and it's a recommendation that when you go into a contract with a general contractor, there's some money that needs to be put into allowances and contingencies on those contracts, because they can estimate an extent of the repairs, but then once the demolition starts is when they really know the extent of the repair. Maybe the amount of rivers that needs to be replaced is not, they can really quantify that since before beginning to make the demolition work. And then what happens is that the owners start getting change orders from the original contract. So it's a recommendation that some contingency is put into contracts for that reason. Next. That's a sample of the report, like what you're seeing on the screen. So it's very important that buildings are evaluated systematically, and repairs are done as needed. Don't wait until you see a problem to solve it, because then it's only going to get worse. Special attention shall be made to roofing, stucco cracks, exposed rebars, lack of waterproofing on the exterior slabs, such as pool deck, windows, and doors. And a good maintenance program is a key to maintain the building in good standing and avoid large repair costs or terrible disasters. And I would like to say that some buildings perform better than other buildings, and all depends on the materials used and the way that they were made, several factors. But in essence, like I believe that all buildings shall be evaluated every maybe 5 to 7 years. And buildings that don't perform well shall be evaluated much sooner, because like in our climate, materials can deteriorate really soon. Coastal areas will require more special attention and more frequent inspections. And owner and condo association shall be very familiar. They shall get familiar with all the warranties of the materials, such as sealants, roofing, paint, so they can keep up with a good maintenance scale for the building, and so costs are more like on track. So that ends the structural presentation.
Thank you all so much to the panelists. So as you guys have been talking, we have gotten a couple questions about structural engineering and the 40, 50 year certifications. So I'm going to go ahead and begin with the first question, which is, does the city contact the owners of the building or the board for the 40-year notice of need for certification?
Repeat the question, please. Does the city contact the owner?
Yeah, or does the association contact the owners?
No, the city send a notification to the condominium association.
Got it.
In my opinion, I think so. I don't think that notification is sent to each owner of the building. I think it's the condominium association. I can double check that.
Sounds good, thank you. So this next question is a little bit longer, and I think this question is going to be more for you, Hugo. So it says here, another unsuccessfully attempting to notify the owner, tenant, or condo watcher about a suspected problem. Does the board have the authority to enter this unit to investigate? For example, if a sewer smell is coming from the unit and we cannot notify the owner, tenant, or condo watcher, can the board/management company enter the unit and flush the toilets and run the faucets to get rid of the smell? Another example could be if there is a leak coming from the unit, can the board/condo association enter the unit?
The statutes do, it's a very specific question, but I'll answer in a more broad way. The statutes do provide that condo association, if it's a disaster or something as an emergency, to do what's obviously not using this terminology, I'm just putting it into a nutshell, to do what needs to be done. So that's something that's going to cause, that's an emergency, or it could it could cause a domino effect, and it could cause a huge disaster within the community. Then the answer, it's gonna first it'll depend on the documents, condo documents. But I can guarantee if it's an emergency, that they're going to do everything they can to get into that unit. But there's no clear-cut answer. I mean, if it's deemed an emergency, then I don't see why not. But there's nothing in black and white that that I'm aware of. I'll have to look at the condo docs, but the statutes do provide for emergencies, for the condo boards to take action. But it's always recommended that the association provide notice if it's deemed plausible. So it depends. It's always on a case-by-case basis, depending if it's if it's an actual emergency. So that's the only way I could respond to that question.
Thank you.
Let me jump in. I think I did an incorrect response before. I believe the notice is sent to each owner of the units. But I mean, I haven't received anyone myself, so that's why I don't know.
Got it. So this question, it's two questions separate, but I'm gonna put them in one for you, Raissa. So it's going to be, what dollar amount do you believe should be budgeted to do an inspection? And does the inspection vendor need to have a specific license?
Okay, budget, that all depends on the size of the building and location of the building. There's different factors. I really don't want to say a number. What was the other, if the inspector needs to have a specific license?
Yes.
Yes, it has to be a professional engineer or an architect.
Thank you. Another question is, how can you get structural requirements before the 40-year requirement is posted to the HOA or CDD concerning amenity centers?
Repeat the question, please.
How can you get structural requirements before the 40-year requirement?
Okay, several condominium associations and owners, they request what they call like an assessment before, once they know that the 40-year recertification is approaching, they contact an engineer, a structural engineer and an electrical engineer. So they go and they do an inspection. And if repairs are needed, then, you know, a repair plan is implemented in advance. So they are ready when the 40-year recertification comes, then they already know that they will pass it.
So this question is a little bit, it's not about Miami-Dade directly, but they want to know if there's a similar inspection requirement in Sarasota, Florida.
I'm not aware of. I know that the statutes are for Miami-Dade and Broward. I'm not sure about the rest of the state.
The question is a little specific since we don't know about the actual association itself, but this person would like to know, is it the owner's responsibility to repair the balconies since it is not a shared element? So I guess that would be more for you, Hugo. I guess.
Yeah, I would have to look at the condo docs on that one. Again, it's like I said in the presentation, usually the condo documents add on to items of what's considered common elements. I'm not sure Barbara could maybe emphasize on this one. I'm not sure I'm sure she wrote into this issue in the past.
I have. So most condominiums have what's called a limited common element, and those are your balconies. Anything that's outside of your door is also considered a limited common element if you are the only person that has access to it. And that would fall under the association to repair those balconies.
Perfect. So this question says, in Broward County, is a condo with patio homes that are have less than 3,500 square feet required to have inspection? So they want to know how, I guess, a condominium that has a patio home at the same time and it's less than 3,500 square feet would have to go through a 40-year/50-year inspection.
I would say that yes, but I have to see specific, you know, what are the specific conditions of the property.
Perfect. So there's a question here about 10-year reminders. He didn't emphasize exactly what about the 10-year reminders, but I'm not sure we have enough context to answer that question. So we have another question that's a little more specific, which is, roof shingles are advertised by roofing companies as having a 20-year lifespan. The HOA creates a 20-year reserve replenishment plan this year. Our insurance company canceled our policy, claiming our roof was too old. They apparently want them reshingled every 15 years. is there a state statute or regulation that regulates this? Do we have recourse with the insurance company through a state agency, or is this just an excuse and we need to shop around for a new insurance company? This will be more for you, Hugo.
Yeah, I mean, not a complex question, but has many components to it. But the answer is that with insurance companies, they try to wiggle their way out of having to provide coverage, based on my experience, to answer the question. But to my knowledge, there's no statute that requires them to provide insurance coverage.
Got it. Another question from Ali is, inspection without enforcement is not going to prevent more disasters. Does the law in Florida require actions to be taken as a result of these inspection reports, and how is this enforced?
Well, if the inspection, if the reports stipulates that the building is not safe and repairs or repairs are needed, then the building needs to be repaired in order to be recertified for another 10 years. I'm not sure if I am responding correctly to the question.
I think they're just asking if Florida has a law that is requiring for you to receive those inspection reports.
Raissa, wouldn't that be where maybe the city would be involved at that point? Where the city would require those if the report is submitted to the city?
The report needs to be submitted to the city in a timely manner. Once they send the notice and the owner receive the notice, they have the obligation to submit the report back. If they don't, then, like I said at the beginning, the building department issue a notice to the Department of Unsafe Structures, and the certificate of occupancy can be revoked. But I'm not sure if the city goes, back and make sure that the report, that's an obligation of the owner in this case.
Thank you. Another question is, what % contingency do you recommend?
It all depends. That all depends on the extent of the damages, what's the total amount of the contract for the repairs needed. That all depends, but it can be, I don't know, maybe 5–10% of the total amount. Depending on the conditions of the building, that all depends. That's maybe more suitable for the general contractor.
Hugo, this is a very long question, says you're for the lawyer. And the question here is pretty specific, but I'll read it anyways. It says here that right before the concrete restoration job on a condo building finished, the city came to inspect the final phases and put a violation for unsafe building. It seems like while they were fixing a wall in one unit at the ground floor and found some issues, this particular unit was most likely built illegally and took part of the ground level parking space. Now the owner of that unit, which has a folio existed since the late 80s, wants the Hill Association and owners to participate for the supposed structural issues that in reality are confined to that unit. In the meantime, while on the ground level, they are also requested a soil geotechnical test to determine the solidity of the whole building.
Yeah, I'm gonna need more information to respond to that question. It's a very, very specific question.
Yes, and Mr. Anonymous attendee, the one that asked the question, after we go through the questions, all the contact information will be on the PowerPoint. So if you want to always email Hugo or Ms. Lopez or Barbara for questions directly, you are always able to do that as well. We'll be able to get more context to answer the questions better. So Ms. Conley is asking about how much for a contingency fund is normal. And like we stated, that's more for a general contractor, and every building is completely different and it requires different funds. Right, Ms. Lopez? In terms to Ms. Thomas's question about who is usually responsible for the repair issues related to balconies, as Ms. Barbara said, that is in most condominiums a limited common element, which would then the association would repair those issues related to the balconies. I don't know if Barbara, you want to explain more, but I think that's pretty much it when it comes to the balconies itself.
The only thing I could add to what Raissa and Hugo have said today is that as board of directors and homeowners, please be aware of your budget. Make sure that you have proper reserves and for all these items. There's a question on here as well saying, hey, should I wait till, we don't want to wait till year 39 to plan for a 40-year certification. You're absolutely right. Don't wait till the last minute. Have proper reserves. That way you're budgeting correctly. So you're not waiting to the last minute to do a massive special assessment in order to repair your building. And always maintenance. Every 10 years, if you live on the beach, if you're on the beach, it's recommended to go through the structural studies and everything like that.
Thank you. Raissa, this is a question for you. Is there a size building requirement certification?
Is size?
Yes, they're asking if a certification required for a 6-unit, 2-story building, condo building. So I'm guessing they're asking if for you to have a 40-year, is there a certain size you have to be or certain floors?
Every building that qualifies, if every building that is not a single family home or a duplex, everything else qualifies.
Okay. So the size doesn't really matter. It's really about if you're a condominium and if you are a building with multiple, common elements.
Correct.
Affecting everyone. So Michael's question about does this guideline apply to 2- or 3-story 50-year-old buildings? It does, since it is a condominium itself.
Correct.
So we have a question here that says, so what is a board to do if due to the recent catastrophe causing a knee-jerk reaction, the waiting list for a competent structural engineer to just inspect the building are booked solid for months and months out, let alone if needed repairs being likely years out?
I'm sorry, what's the question again?
They want to know what they should do that now everyone is reacting to the situation if all the engineers are going to be booked for months and they can't find an engineer to actually fix the repairs.
That's a very good question, because I unfortunately since the disaster of the Champlain Towers happened, everyone is getting more aware of they want to get checked their buildings, and we have been having a lot of calls and a lot of requests for. So right now, we are, our office have 4 PEs, licensed professional engineers in the office, and we're booked like for, I would say, the next 2 weeks, maybe more. And unfortunately, it's not only the time of the inspection. I mean, you go sometimes if the building is a big building, a large size building, sometimes we have to go more than once. And sometimes we go and we say, oh no, you need to open this, and then you need to open this other place, and we have to go back. And sometimes we can get access to every single unit, so we have to go back. So sometimes there are several inspections that we have to go, and then we have to create the report. That's also time, so it takes time.
Thank you.
There are several engineering firms in the South Florida area, so I'm pretty sure you can find an experienced one.
We have a question here that says, is there a specific Florida statute for the 40/50-year inspection that we should be aware of?
In the act, no, it's all by, that's more of ordinances.
So it's basically city-based and county-based.
Correct. So on a per county basis.
And the ordinance supersede the Florida Building Code.
Yes. How elaborate does a remediation for a particular structural problem have to be? Is it more as a suggested fix, or does it have to be submitted with analysis of the solution?
It all depends. It depends. There's no like a specific answer to that question. It all depends.
How many condominiums do you know of that include the entire building or buildings in their reserves, since the building itself is less than 10,000 and has a definitive maintenance lifespan, albeit somewhat large?
Repeat that question one more time.
You don't know question.
Yeah. How many condominiums do you know of that include the entire building or buildings in their reserves, since the building itself is less than 10,000 and has a definitive maintenance lifespan, albeit somewhat large?
I don't understand that question. I don't know how to answer that.
I guess that question, Spencer, was very specific, and I guess every building has their finances completely done differently. What should you do if the board of directors do not cooperate when notified of damages and they take no action regarding structural repairs?
Well, from a legal standpoint, if you're notifying the board of directors of, potential structural damages and they're not responding or being responsive, next step would be to contact the county official to report it.
Are the regulations for inspection applicable only to Miami-Dade? Alternatively, are there any statewide regulations that apply to recertification of the building? And like we stated earlier, all these inspections are on a county-wide basis. So every county has their own regulations when it comes to these certifications.
That all depends on what type of repairs, what type of inspections are we talking about. Inspections are required state-based, but it depends if the building is a threshold building. It depends if they get a private company doing the repairs and the inspections as a private provider. It all depends. There's not like one answer that would suit every case.
Got it. A second, I'm reading through the questions. Should remediation for a particular structural problem be completed in full, or does a board have the right to only do partial repairs? Is it more as a suggested fix within the inspection report?
Every repair should be done properly. For example, if it's a concrete element, there are recommendations done by the American Concrete Institute how to repair for a specific problem. And if you don't, for example, if you have like a crack in a beam, and you just patch it with grout, you're not doing anything. You're just throwing out your money. Repair, but again, there are cracks that are due to a very serious structural problem, and there are cracks that are due to water infiltration and corroded steel. That's why an inspection is necessary by an experienced engineer.
One other question we have is, how often should a reserve study be completed?
It's for Barbara.
Typically, you want to do a reserve study at the inception of the condominium association, and then follow it up with every 5 years as cost goes up and inflation has to be calculated into it.
Next question is, we're almost done with the questions as we were nearing towards the end of the webinar, but the question is, can you put into reserves the cost of a 40-year inspection?
I want to say yes to that. I think it will be in the best interest of a board of directors to put a line item together of maybe structural components, and that would, but you can discuss that with a reserve study advisor.
Thank you. Our two-story condo building is 18 years old. When will the first inspection be required?
I would say maybe depending on how the building looks, depending if you see like anything that like any crack or any small concrete, any rebar exposed. If you see water coming in, if you see 18 years at least for the roofing, I think maybe that's getting into the end of the warranty. I believe the warranty on roofing products are like 20 years. So depending on how the building performs, at least maybe I wouldn't wait much longer. If the resident sees something that it's like concerning right now. If not, then in the near future.
Perfect. And is there any, this is more for you, Hugo, is there any pending legislation that will require regular structural studies?
Well, prior to, I believe it's 2010, there was a Florida statute that required an inspection every 5 years. My gut feeling tells me that they're probably going to push to have that statute be amended to read that way, because right now, as we speak, it doesn't read that way. There's no requirement. But then again, if you're put on notice, so the board is put on notice, it's always the board's obligation to do what's in the best interest of the association. So although, the county requires 40 years, or 40 to 50 years recertification, it's always, best to do it beforehand. I believe as Barbara commented and Ms. Lopez, and not wait till last minute and, try to find an engineer last minute. But to answer the question right now, to my knowledge, there's no statute that requires that, but there was one prior to 2010 that required a 5-year inspection of the building.
Perfect. Thank you. So we have reached the end of the questions. Thank you, everyone, the panelists and everyone for staying for the webinar itself. On our screen here, we have put the contact information for the 3 panelists here today. If you have any questions that you want to ask the panelists specifically, you can always email them and they'll gladly get back to you as well. At the end of this webinar, we are also going to be sending you within 24 to 48 hours a copy of the presentation and the webinar itself. We thank you very much for being here on behalf of Vesta Property Services, Florida General Counsel, and the Eastern Engineering Group. We thank you so much for spending time with us today and hope you have a great weekend and stay safe.